Well, it's very unfortunate, Mark, that when you were dismissed, first of all, you haven't been an employee long enough, and secondly, that you're not a pregnant woman or a person of an ethnic minority or minority sexuality or anything really, because if that happened, then you could sue in an employment tribunal for discrimination, which doesn't have a minimum time period of service.
Sure.
In a way, you've fallen into a very unfair category of being someone who's has a contract, but who otherwise is really well doesn't have much in their armory because the way the law is, in my opinion, quite unfairly worded in favor of the employer. And in fact, now you require employees who started after April 2012 need 2 years of continuous employment before they can sue for unfair dismissal, up from 1 year, because the government thinks it will protect business and stimulate the economy, which is complete nonsense. But it leads to people like you time and time again being abused. But anyway, that is my bit of morality, I'm afraid, in ranting. Let's get back to it. So what we have is their own procedures being breached. What that means is, firstly, a contractual breach, and secondly, there's an ACAS code of practice, which applies even though you're not up to the threshold of being of having 1 or 2 years employment. So although you cannot sue an unfair dismissal, what you can do is you can say these are the procedures which should be applied to any employee, and clearly they weren't in your case. A question which actually troubled me, and which I think the defendant, in their first letter of denial, they say, okay, well, it's fair. I mean, this is a without prejudice letter rather than letter of denial, saying even if we did screw it up more or less, but even if we got it right procedurally, it wouldn't have made a difference.
Yeah.
I think arguably in a case where it's your performance which is